Kevin? You good? Thank you guys for being here. First, because today is April 1st and we're live streaming, I've got to wish my wife a happy 10th anniversary and tell her that I will be home right after you guys are done with me. Last night I viewed a letter from the governor stating that under KRS 48621, he was cutting the budget appropriations of Kentucky's universities and community college for this fiscal year by 4.5% or $41 million. While the governor's letter referred to a reduction in allotment or allocation, by cutting at the end of the year or in the fourth quarter, he was unilaterally cutting or reducing an explicit appropriation made by the General Assembly in the current controlling biennium's budget. He was cutting completely, not just changing the timing at which a university would receive their funds. A governor, any governor, does not have this power or authority. The governor's actions violate explicit statutes that govern budget reductions. They violate last year's biennium budget, the last 2 years' biennium budget, which became law after it was passed by a 37-1 Senate vote and an 89-11 House vote. And these actions violate the separation of powers mandated by Kentucky's Constitution. In fact, the governor's position would mean the General Assembly merely suggests how the governor might spend money if he so chooses. A budget passed by the General Assembly is a mandate, not a recommendation, provided there are sufficient funds. And when there are not sufficient funds, a governor cannot simply choose a specific group to cut. Instead, there is a law on how he must act. You all have seen it more than a few times in the last several years. To trigger a budget reduction, one of two events must occur. Either the consensus forecasting group must issue an official revenue estimate reflecting a revenue shortfall, or at the end of the fiscal year, there must be an actual revenue shortfall. Neither is the case here, and neither is the case now. But if they were, still additional steps would be required. First, under the law, the unappropriated balance of funds in the surplus account of the general fund must be used to meet any shortfall. If that's not enough, then the governor must turn to the budget bill, the last enacted budget bill, first. That budget bill, again, is a law. It is passed just like any other statute into law. And if you look back at that biennium budget for the last 2 years, it contains a specific provision about any shortfall. And it lists exactly how cuts must occur, and even the order they must occur in a cascading order. Cutting universities does not appear on that list at all. And cutting general fund appropriations to the executive branch agencies appears sixth on that list, which again only comes after any surplus funds in the general account. To be clear, the governor has not taken any of these steps to date. Instead, the approach he took was to put a 4.5% budget reduction for this fiscal year into the next biennium's budget. And that would have been legal because the General Assembly would have changed an appropriation through statute. But to date, he has failed, and that does not allow a governor to go beyond what the law allows. Now, a university could voluntarily agree not to spend its full appropriation, but we all know that cuts to university directly result in tuition hikes. And in my opinion, a university president that would voluntarily agree to an action that raises tuition would be a dereliction of duty. This is not about political drama. This is not about elections. And this is not any Bevin versus Beshear. It's about the law. It's about what the Constitution requires. It's about how the Constitution protects our liberty. Under the logic put forth by the governor, he could shut down all of government by simply refusing to allot any money anywhere. Or he could totally refuse to allot money, shutting down any office, unit, university, program, or institution at his whim. He could shut down Operation Unite. He could eliminate Child Protective Services. He could close the Kentucky State Police, or even defund the legislature itself. That is the exact type of power our democracy, our Constitution, and our liberty explicitly forbid. I was reminded in an email yesterday about how when we were both elected, the voters of Kentucky expected Mr. Bevin as governor and myself as Attorney General to work together. And I take that seriously. This is not me trying in any way to personally hurt or make a statement about this governor. Because of that, the first step I am taking is calling on the governor to rescind this order cutting universities by 4.5%. Over the next week, and hopefully later this afternoon, we are going to provide the governor our opinion in writing. My deputy, Attorney General J. Michael Brown, is reaching out to the General Counsel to request a meeting. We are going to give this governor the next 7 days to reconsider, to look at the law, and to rescind his order as to universities. And at that point, he can go back to working with the legislature, with the General Assembly, to try to create any savings that he would like, but to do so in a way that the law allows. If the governor chooses to rescind this order, I will support him fully. It is the right thing to do. It's the legal thing to do. If not, we'll resort to litigation. Thank you all, and I'm happy to answer any questions. Well, the Attorney General has standing to enforce the laws of the Commonwealth as well as our Constitution. It's exactly what this office was created to do. In the end, Jack, it's my duty. And whether this was the House or the Senate or any Democrat or Republican, I would have the same duty to say that the law is not being followed.
Did the governor recommend that the legal staff consult with your office before doing this?
They did not. I saw this last night for the first time through a PDF that was sent to me by my own staff. We have not yet. No. I mean, from the start, this is my duty as the Attorney General. And again, it's not political. This is not in the end about elections. It's what you can and can't do under the Constitution, and what you have to do under the law when there is a revenue shortfall. You know, the legislature, in setting this up, didn't say any governor could do anything at any time with regards to the budget or what to do when there aren't enough funds. Now, there are enough funds under at least the statutory framework. What we're trying to do is enforce the steps that must be taken under those laws.
A couple of months ago, the governor announced that he was going to push with this budget press. So you had to know that this was coming at any point in the past couple of months. Have you approached him to talk about this or tried to give him counsel on your opinion before he came to this?
Well, Chris, the way he was originally pushing for it would have been legal, and that's to include it in this next budget. So it would have been an act of the legislature where they can change the appropriation while they're in session. So the original manner in which he went about it, which thus far has failed, would have been legal, would have met the law. But doing this unilaterally through an order from the governor, the signed letter, simply does not comply with the law. Mm-hmm. Well, only in the level of process that we hit. So if the governor had a shortfall, which would be required to cut his cabinets or agencies, because again, money's been appropriated, mandated by the legislature to go to those agencies, what would have to happen is either the consensus forecasting group would have to change their forecast and say we have a shortfall, or you have an actual shortfall at the end of the year. At that point, you'd have to look at that biennium budget bill that passed. And I believe sixth on that list is the governor's executive cabinets and agencies. At that point, he could make those cuts, but only in that cascading order of using funds. Correct. Mm-hmm.
The governor's apparently directing cuts to other agencies, presumably the current
Well,
same percentage amount. That would apply as well.
it should, yes.
Your legal point.
To cut amounts appropriated, mandated by the General Assembly, and not merely change their timing, allocation versus the apportionment, allocation versus the appropriation. There would have to be a declared revenue shortfall. We haven't reached that stage. My hope is that in working with the governor's office, it doesn't have to come to that. Well, we are. It'd be closed business in a week. The last set of funding that he is attempting to cut is the funding for the last quarter. If we can get this fixed in the next week, then our universities still receive the funding that they expected, have budgeted for, and have relied upon in the last quarter where they need it. Well, we'd have to start in Franklin Circuit Court if we chose to file there, and what we'd seek is a declaratory judgment and an injunction, but we are not there. Again, I am committed to trying to work with this governor. This is our legal opinion, and it's the law. We intend to meet with, to provide that opinion to the governor, and we hope that he will rescind his order and begin working with the legislature to accomplish any types of savings or directives that he'd like.
The governor says he's not appropriating money.
Mhm.
He's just reducing spending, which
Right.
the law decides on how to fund it. It's
the-
giving him the authority.
The law he cites talks about allocation, talks about the when, not the how much. The law he cites may say that he can move a little from this quarter to that quarter, or this month to that month, but doesn't let you cut funds that have been appropriated. Otherwise, Adam, you could say we're sending $41 million to this university. That's our mandate because the legislature believes in this university, and the governor could sign into law and afterwards just say, nope, it's not going there at all. I've decided my allocation power is superior to your mandated budget bill.
Your statement about university presidents being there, several of those universities are saying they're going to comply with this.
Well, I don't think the university presidents have heard what we said today, and I seriously hope that they would reconsider after understanding the law. They have budgeted for the last 2 years according to the last biennium budget. They knew what they had coming in, and we have seen at a time when college has never been more unaffordable that every single cut results in a large tuition increase. A university president has a duty, first and foremost, to the students at that university. They are entitled to these funds from the last budget. They should not say no to them. They should accept them, and they should hold tuition down as much as humanly possible. That's what our students deserve. We talk about not balancing our budget on the backs of the next generation. Well, what is increasing tuition? It is either eliminating opportunity for the next generation, or it's certainly balancing this budget on their backs. I disagree. Under the law, if you would like to cut universities, you have to have a budget shortfall, which does not exist, at least under the law, and then you would have to go through this series of steps. Because again, the legislature has said, under our power, if there is any time in the next 2 years that you don't have enough money, here is how you must address it. And they passed that into law, and the governor at the time signed it. I mean, that's a mandate. That's their power under separation of powers. Well, the consensus forecasting group has not met and has not changed their revenue outlook. That's included in the statute. Or at the end of the year, which we haven't hit, revenues would have to be under projections. They're currently over projections. And those two things are actually within statute. It's an either or under the statute. I believe so, yes. Well, I think with regards to the life insurance policies, that was a decision, at least as I know, made by the Department of Insurance. about what they were going to pursue or not pursue. I'm not going to suggest that decision was or was not made by the governor. On this instance, my hope is that the governor has not been advised or will be advised about the specific legal requirements and that litigation will not be necessary. But in the end, if we're forced to do it, it's because it's my duty. And it doesn't matter if I'm a Democrat or a Republican, and it doesn't matter if he's a Democrat or a Republican. In the end, the Attorney General has a duty to make sure the statutes and the Constitution is followed. Because if you look at the governor's position, it would mean that the legislature is totally stripped of any budgeting authority and really any other authority that requires any funding at the whim of the governor. Well, let me say that you have to have a legitimate cause of action to file a lawsuit. If you don't, there are repercussions. And if you want to evaluate this lawsuit, if you have to evaluate our position, because we hope it does not come to a lawsuit, all you have to do is read the statutes. This is pretty clear. In the end, there's a Constitution, which supports our position and suggests the governor can't do what he's doing. There are specific statutes on how you handle a budget shortfall, which the governor is not following. And then you have the last biennium's budget, which puts in very explicit detail what you have to do when you reach one. So we are very confident in our legal position. Hope the governor will reconsider, and hope that after that he can get back to budget negotiations with the House and the Senate. I've not had an opportunity to speak to the governor today. We didn't receive any type of advance warning last night. We've been researching and making sure our positions are solid, which they are, and we'll be looking forward to working with the governor in the next week. Now, our action, again, that we're taking here today is calling on him to rescind that order. And if he will do that, I fully support that position.
But you're calling on him by going through us and us broadcasting and reporting it. Does that constitute maybe you have an icy relationship with the governor?
Well, I try to work with the governor whenever we can. Certainly, we've seen bipartisanship on child abuse as well as sexual assault. So I think that there are many areas that we work on together. But what I received and what I reviewed is a letter directing universities to do something in very short order that does not comply with the law. And so we believe immediate action was necessary.